G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers. And today I'm talking about surrogacy in New South Wales. This is a topic near and dear to me. I think my first New South Wales clients with surrogacy were about 2007, 2008. And really, they were going overseas. It was possible, but difficult to do surrogacy before the enactment of the Surrogacy Act 2010 in New South Wales, which commenced on 1 March 2011. And it's funny, I remember that date because not only, I happen to remember the date because I've dealt with it so many times, but on that night there was a broadcast for SBS Insight about surrogacy and I was part of the panel. It's funny. But if you wanted a potted version about surrogacy in New South Wales, go to my book, When Not If, Surrogacy for Australians. There is a chapter there about surrogacy in New South Wales. We've got other chapters about how to find a surrogate and choosing who wants to be parents through surrogacy, etc. Lots and lots of chapters, but one specifically about New South Wales. And at the beginning, I'm sorry it's small, but my mud map of how to do surrogacy in New South Wales. So the starting point for most people is they're going to do surrogacy, they're going to have an embryo. So you've got to create an embryo. And different IVF clinics approach this in different ways as to what they're going to charge. So it's good to get advice early on so you know the differences about how clinics operate. But be assured that whatever clinic you go to, it'll be very, very good. The quality of Australian IVF clinics, in my view, is excellent. And I don't say that because I'm a director of the Fertility Society of Australia. Well, I am. And I don't say that because I have a financial interest in any of these IVF clinics. I don't. I'm not an owner of any of these clinics. But I say that because when we look at the objective data, our clinics really are top-notch, and in many ways Australian clinics have led the world. So I'm very proud of local clinics. But having said that, you create an embryo and then you've got to go through the formal processes, and the formal processes are really three things to get the ball rolling. You've got to have a written surrogacy arrangement, and before that, and the people who sign up to that, I should say, are the intended parents, one or two, so single or couple, and surrogate and surrogate's partner. And the jargon used under the Surrogacy Act in New South Wales is birth mother. So birth mother, birth mother's partner, but I say surrogate. And it's got to be written and it's got to be signed. And before you enter into that surrogacy arrangement, the three things are, number one, is your surrogate medically okay? Is she suitable to carry? Because if she's not, then you put in the cart before the horse. So go and get checked out. Fertility specialist and maybe obstetrician as well. Secondly, you've got to make sure that you have fertility counselling undertaken, so that we just check that everything is okay. And you won't be signing the surrogacy arrangement until that report comes back and says, no surprises, everything's good to go here, recommend the surrogacy arrangement. And these counselling reports are thorough. They're really good and thorough. And they must be provided to the clinic, and ultimately they get provided to the Supreme Court of New South Wales. And so that's the next lead in. Both sides get independent legal advice. So the surrogate on one side and partner, and on the other side, the intended parents. Not as one law firm tried to do, as I saw, that said all four parties must have a different lawyer. Crazy. The legislation does not require that. Once you've got the signed surrogacy arrangement, both lawyers give legal clearance to the clinic. It used to be that the agreement would be provided to the IVF clinic, but some years ago I wrote to the Fertility Society and said doctors should stick to their knitting, which is about the medical stuff. Lawyers should stick to the knitting, which is the legal stuff. Can we give legal clearance instead? And the then president of the Fertility Society agreed and wrote to all the IVF clinics. So that's how we do it. Each clinic has its own processes. Some are less formal, some are more formal, some are quicker, some are slower, but they have an approval process within the clinic. Once they approve, then away you go. But you must be thinking at the beginning of the process about some basics in terms of your surrogate. What hospital is she giving birth in? Is she a private patient? Is she a public patient? Is the hospital welcoming to surrogacy? If she's a public patient, is she in the catchment? And if she's a private patient, and the intended parents are either paying the fee at the end of the day, or they're paying maternity cover plus whatever catch up there is. If they're paying maternity cover, it's a 12-month waiting period. When the surrogate gives birth, the surrogate and partner are the legal parents, and therefore they are responsible for registering the birth, shown on the birth certificate as the parents. But the child's name can be that chosen by the intended parents. And 1 to 6 months post-birth, an application is made to the Supreme Court of New South Wales for a change of parentage with a parentage order from the surrogate and partner to the intended parents. There is a raft of affidavits that are required, including reports from doctor, counsellors, etc. And the application is typically not made in front of the court. I've had clients do that, and it's been a joy to turn up in the Supreme Court and get an order made. But the Supreme Court of New South Wales does most of that by paper, and the length of time varies. It's supposed to be 3 weeks, but it's common to have the order made after 9 weeks. When the judge pronounces the order, makes the order at that point, puts their seal on it, then the intended parents are the parents and the surrogate and partner are not. And that's for all purposes under Australian law. And then the Supreme Court sends the orders, assuming the child's born in New South Wales, off to the Registrar of Births, Deaths and Marriages. Typically it's 6 weeks after that before the birth register is updated and the new birth certificate issues, and that's the end of the process. Sometimes, however, birth, deaths and marriages in New South Wales are not so quick. And we've had, clients of ours have had great delays. And indeed today I'm putting in a submission to New South Wales about its surrogacy process, and that submission is here on the website, so I just want to make sure you see it. And for those listening to the podcast, go and have a look at my website, www.pageproven.com.au, and you'll see my submission about the Surrogacy Act, because the New South Wales Department of Communities and Justice is undertaking a review of the Surrogacy Act. So I've put in a submission, and as I said, it's on my website. And that's it. Let's see if there are going to be changes to the law in New South Wales. There's a bill currently before Parliament. I don't know whether it's going to go up. It's concerning commercial surrogacy, and there's this other review. But in the meantime, until it happens, that's the state of play in New South Wales. I'm Stephen Page from Page Proven Family and Fertility Lawyers. Thank you for listening and watching.